we're permanent jammy time over here.
Well, I want to welcome you, jammies or no. I love that. I don't know if you've seen that show with the Good News Show with John Krasinski on YouTube, but he wears a suit and tie, and then he stands up and like he's in boxers or briefs or something. So, who knows what's going on down there?
It's like the Muppets. It's Frank Oz actually operates me with his left hand.
Right. Well, I'm excited that we're going to cover this topic because it may not be a very sexy topic, but I think it's an interesting one because it's so gray from where I stand. And so let me just introduce our topic for today, just for purposes of the recording. I want to say welcome to all of you who are here for our discussion on what about copyright? As artists, what does it matter? How do we honor it? How do we protect it? Where is the line? And I think it's an interesting, somewhat technical discussion, but I think it's good for us to become sensitized to the issues that might be out there for us as artists. And so I want to welcome today a couple of guests to the discussion who are going to be kind of leading the discussion and available to just kind of chime in. But I want to also invite all of you who are present to feel free to think about asking questions and, chiming in if you have a question, either through the chat function or just by unmuting your microphone. I would ask for purposes of the recording that you just stay muted when and where you're not actively speaking. But my name, of course, is Rebecca Zadibble. I go as Rebecca Z Artist on social media because my last name is so difficult for most of us to say or spell. And so Rebecca Z is my handle on Instagram and Facebook. I teach and do my art thing here in Myrtle Beach in my studio, 9713 North Kings Highway in Myrtle Beach, South Carolina. It's my pleasure to introduce also my good buddy, William Miller. William, I'm going to let you introduce yourself.
Yeah, I'm William Miller. I've been a full-time artist since 2012. I've got my studio and gallery in downtown Myrtle Beach. I'm a painter and digital artist.
Great. And I'm so glad you can join in this discussion. And my other special guest today is James Arendt from Coastal Carolina. James, can you tell us about yourself?
Sure. You guys can all feel free to call me Jim. And my last name's a hard one too, so I'll just phonetically say it for everybody. It's like, why aren't we at the beach? That's how my name typically rolls off the tongue where I'm from. I work at Coastal Carolina University. I'm an associate professor of visual art, and I run the gallery system. Rebecca has graciously invited me to participate in this conversation, which I think is going to be actually a really lively discussion, because I think here what I'm going to tell everybody is good people and good minds can disagree about these issues. And I'm going to touch on some of the copyright issues and the philosophy, both from a legal standpoint and from a moral standpoint. And so those two things are often at odds with one another, and I'll be happy to entertain questions. I should point out I'm not a legal scholar. I'm a practicing artist and somebody who interacts with it from a maker's point of view. But I have encountered enough discussions around copyright that it should be entertaining for everybody.
Yeah, I look forward to it. I agree that I think this topic is a gray one. You can read about it, you can hear about the progress of legal cases pertaining to copyright, and you can see that even courts at different levels will disagree. One level of the court saying, yes, it's a violation of copyright, and another level saying, maybe not. So I think not only will, conscientious people potentially disagree on this subject, but the courts do too. So it's hard to know where that line is. So what about copyright? Why do you think what do you think are some of the fundamentals that people need to be concerned with when it comes to keeping track of copyright and how it pertains to being an artist?
Well, I think we should kind of back up in time a little bit to understand how we got to now. I think understanding the history of copyright and its intent is really important. But I want to just kind of assure everybody that there's nothing special that anyone has to do to seek copyright for your work. I think one of the most fundamental kind of nice things about copyright law is that it's immediate. As soon as you bring an object into the world, it's protected by copyright in the full force of the law. There are additional steps you can take, like registering with the U.S. Copyright Office. But if you've made it, it's protected by copyright in the United States, at the very least. And it's important to understand that, you know, copyright in the United States versus copyright internationally can be slightly different, although there's a lot of international accords that try to bring those things into alignment with one another. Having said all that, and I'm going to kind of rush 40,000 years of visual image making, I think it's important for all artists to understand that for most of our history, which remember predates the written world by at least 45,000 years, none of our works were protected by copyright. And that's what we call the public domain. And so the discussion that I'm going to, I'll hand back to my host here in just a second, but the discussion that I kind of want to trace for everybody today is the purpose and the intent behind copyright, why it developed here in the way that it did, how it's manifested, and how it's changed over the years, which I think is a really important topic to understand, and what it does for us in both a positive and what it does for us from a negative point of view, because it does have both aspects.
That's an interesting.
And Rebecca, I'm going to hand back to you.
That's an interesting point, that what we call now public domain is actually that period of history when copyright wasn't really applied, and no longer applies. Typically, what is that? I think anymore, it's like 70 years, is that right?
Well, so the letter of the law, let's talk about that. You're right. The public domain, as we understood it, essentially no longer exists. Anything that's been created in the last 100 years still falls under copyright law because the law has been expanded in such a broad fashion. So the works of Shakespeare were never protected by copyright. That's why his friends could get together and offer us the folios. You know, they thought these were works that should enter the public domain. It should be good for everybody to read. And so they were published. No one paid William Shakespeare's estate a dime to do that. It was his friends getting together as a way to say, hey, Old Will was pretty good. We shouldn't let these things just disappear. Let's publish them and put them out there for everybody to enjoy. And that's what the public domain is. The public domain is kind of our storehouse of culture. And we all exist in it and we pull from it. It's really the creative soil that most artists draw their ideas from. Now, what's happened to our copyright law, which is written right into the Constitution of the country? We can go back and look at Article 1, Section 8, or Article 8, Section 8, I think it is. It was originally written for the advancements of sciences and the useful arts to protect people who brought new works of literature, eventually visual artworks, into existence with a brief period of protection so that they could earn back their development costs, essentially. So if you made something or if you wrote a book in the United States, initially it was 20 years. You could have that as the exclusive right. And here's where the right part of copyright. It was your right exclusively for 20 years to publish your book, or to license it to others to publish it on your behalf, so that you could recoup the costs of bringing that new work into existence. And then after 20 years, it became something that belonged to everyone. So all of your Penguin Classics, your Dover reprints, your great works of literature were all things that have entered the public domain and are simply repackaged and resold to us by different publishers. And so they're not protected by copyright anymore. And it's important to think about the word right here. Copyright doesn't refer to kind of our liberties. It's not an innate right to works that you create. It's really a privilege that we exercise. So this right in the word refers to our ability to do it. And so it's a brief period of time intended to protect the work that you develop so that you can record your cost of development exclusively. And then it becomes something that belongs to everybody. That's the intent. Now, the law has been revised several times, 1912, 1978. Most recently, Disney and their lobbyists have extended copyright to be the life of the artist. So think about your age currently, the life of the artist, your entire period of life, plus 70 years. What that has in effect done is it has kept anything from entering the public domain, let's say at least since 1978. It may extend backwards in time as well. I'm a little hazy about the legal. So the prime example of this is Snow White and the Seven Dwarfs. Anybody remember what year Snow White and the Seven Dwarfs was made? Beautiful movie, still holds up today.
1939.
Very close. Very close. 1937. And that work was based on a Brothers Grimm fairy tale published originally in 1812. And the Brothers Grimm's work were apocryphal stories gathered, public domain stories already, right? Let's take a folk story, one that's in the public domain. We'll write it down. We'll publish it. Approximately 100 years later, Disney makes Snow White based on that public domain work. And it should have, after 20 years, entered the public domain as well. Now, what's happened is it's been extended to, I believe, Snow White may come into the public domain in 2046, would be a window. But that is a moving target these days. What I suspect will happen is that copyright laws will be rewritten to favor ownership, and the public domain as we understand it may be a thing that's an anachronism of the past.
Wow, yeah, it's like the lobbyists could have a definite influence on how the laws go from here on out. But that's really interesting. I think the whole concept of, where is the line that you don't have to worry, is I guess essentially before like 1940 now? Is that 70 years ago? No, 1950. So it's a moving target though, and I think that the whole idea of where is it safe to go to get images is a very gray one. And what are the consequences for us if we go into the public domain or what we think is the public domain and grab a photo, say off of Google, and we use it as a foundation for what we're doing? What do you feel like are some of the William, what do you think are some of the things that we need to be worried about if we're going online and looking for images?
I think, first of all, you have to look at what and how you're using and appropriating. So, we could start with photographs because that's probably what most artists go to when they're drawing or using. So I think it comes down to, a lot of new artists are, and maybe it's not the trend anymore, but I think maybe Jim can answer if he sees this, but they are appropriating what they see on cartoons and on animated shows on television, and they're taking those characters and redrawing them and repainting them. If they are doing it exactly as those characters are meant, they are violating that original artist's copyright, or studio who owns that artist's copyright. Then you have now what's the gray area, which is, are you taking that and doing a parody? Because if you're doing a parody, then that is acceptable as a new derivative artwork of that. So that,
I think transformative is a term too that gets tossed around, is what you're doing transformative of the original.
right. So that's how the artist Cause can get away with his huge Mickey Mouse-like figure with the X's on the eyes, and because he has transformed or done a derivative work based on the original mouse figures. When it comes into photographs that artists use to repaint, I think, it's twofold. That copyright is owned by that photographer or the company that paid that photographer to take that photo. So the best thing is to reach out to that artist and ask if you can use their photo as a reference. It gets down to how much of that photo do you actually copy. And I think generally copyright, I think a lot of times doesn't necessarily apply to artists that, it applies to them, but it's not a big worry, because unless you're making lots of money, that somebody's going to sue you to do this. The first thing that they'll probably want to do is send you a cease and desist letter, and then you have to destroy any of the originals and stuff. But, if you're taking a picture and painting it for your grandma, and, she's going to hang it in her house, I think you can get away with that.
Yeah, there's good manners, and then there's the legal world too. And so I think you're right. I think if it's just as a hobbyist or as just someone who's getting started and you want to start with something, I think copying and imitation is frequently where people begin when they're just starting out. So yeah.
But here, Rebecca, if I can jump in just for a second.
Sure.
It's important for everybody to think about how much creativity relies on our ability to copy. This is where the law comes into conflict with what we do. The basic elements of creativity that we all have access to are to copy, right? That's where a lot of us learn. We have heroes that we emulate. We play covers of songs. We often copy paintings to teach us what it was like to be another artist. That's a form of time travel that a lot of artists engage in. I love that. Your friends are centuries dead. But copying is fundamental to what creativity is. Transformative aspects grow out of that, and then combinations of separate ideas. And we can see how much we appreciate and guard our own ideas as things that they belong to us. They're ours, right? We have a cognitive bias called loss aversion. When someone takes from us, we really feel it. It feels like somebody's stolen something from us. But when we take from others, we call it emulation, or we call it an homage, or we call it all these different sorts of things. So we don't feel the pain. We have the gain, and we don't acknowledge where the gain comes from. We don't acknowledge how all of us got to here. Whether you're a painter or a photographer, you are lifting from centuries of other artists' previous work all the time. And so copyright as a legal fundamental is often in conflict with the very nature of what we do. And so it's important for us to kind of advocate for our right to copy and to not live in fear. Fear is a great creativity killer. And I'll kick it back over to you.
Oh, that's so true. I think you're right. Now, in our chat, you'll notice that, was that you, Jim, that put this in there, or no?
I dropped in this link to a really great short introduction to the idea of both where ideas come from and where creativity comes from. A lot of the topics that you'll hear me talking about comes from this short video series. It's called Everything is a Remix. That's the first link at the top of that chat. And it does things like it traces the roots of Led Zeppelin songs. And Led Zeppelin, by many of their contemporaries, were considered rip-off artists because most of their songs, like Stairway to Heaven, are direct rip-offs from artists that they toured with. Led Zeppelin benefited and became famous on the backs of other people. And Rebecca, you had mentioned this a little bit. There's a difference between appreciating someone, copying someone's work, and being a dick. Right? A dick steals without recognizing where the material comes from and takes credit for other people's work. Someone who loves, right, always tips their hat to the work that came before. I remember back in the 90s, Nirvana played on MTV an acoustic session, and they played lots of songs that everybody thought were great songs, but they would say at the end of every one of them, this is a David Bowie song, this is a Lead Belly song. All the covers that they played, they acknowledged. And that's a form of legal copying. That's not an illegal thing to do. So William had talked about forms of legal copying that I think are important for people to understand. Parodies, satire, almost any work of art. Rebecca, you had used the word transformative. I think it's arguable in a court of law that any work of art is transformative. Even if you took a photograph of an existing photograph, your intent as an artist is transformative. You have made something new, even if it's just a critique an existing work of art. And so, we're talking about some weighty subjects and some difficult subjects. It often opens up a Pandora's box of possibilities, but I think William fundamentally is right. Unless you're Disney, no one's going to sue you. Unless you're Richard Ferry, no one is going to sue you. Perfectly okay to do those things.
Yeah, when you start making a lot of money based on a derivative work, I think that's when you are really at risk. Don't you think? I mean, if you're just a low-key player, you're probably, you might have the risk of being called out or being embarrassed.
Yeah.
But, usually the first step is to cease and desist. And that gives you the opportunity to either retract or pull back or take down a post,
Yes.
for example, or
So
maybe attribution even retroactively.
The cease and desist aspect is mandated by the law. So when you're an entity that has a trademark, the law says if you don't defend your copyrighted items, or really we're talking about trademark now, if you don't defend that, it becomes part of the public domain. Mm-hmm. And so armies of lawyers are tasked with defending corporate entities, ideas, and ideas which, people try to trademark, try to copyright. Ideas are not something you can copyright or protect. It's only the physical manifestations of things. And so copyright has grown to try to accommodate things like intellectual property. And billions, literally billions of dollars are spent every year in courts of law in West Texas, primarily with software companies trying to defend their patents or their copyright or their trademarks from one another, where fundamentally copyright was never intended to protect ideas. It was only for your ability to exclusively profit from a book you wrote, right? A period of time in which you could copy it for others for purchase.
Yeah.
And so it's been mutated into this more all-encompassing, expansive thing, and expanded through trade treaties and all sorts of other things. And it's largely now not designed to help artists like us, right? It actually is detrimental to artists like us, but to defend ideas as property. The fact that Mickey Mouse will never come into the public domain is a good corporate strategy, because as long as Disney owns the exclusive ability to profit from it, they have a vested interest in defending that. Unfortunately, what that means is authority and control over images, and not so much creativity. And so those two things, authority and control over ideas and images, versus people like us getting our hands on them and saying, what if we could do something with Mickey Mouse? Or what if we could make our own Snow White? Or what if we could animate a Leonardo painting? You know, those are the types of creative things that an active public domain is there to guarantee. And that's where creativity thrives. So the more, it's very, I hate to make Star Trek and Star Wars references all the time, but the more they tighten their fist around things and ideas, the more artists slip through the cracks. And they're trying to have a philosophical control over images, whereas we know that images belong to everybody.
Well, it boils down to money, don't you think? I mean, it really does. It's about who's going to profit, and the big dogs who have the teams of lawyers are going to be the ones that steer the lobbies and the laws. And so I think it really is about very much about that. But I do think that it's it's an artist tradition to steal from one another. I mean, you go to Picasso and his buddies when, in the Cubist movement, their paintings look so similar at first. They were borrowing from one another very heavily, probably even copying one another at the time. I think it was Georges Braque and Picasso. And Picasso's known to have said, good artists borrow, great artists steal. And I think
They do.
I feel as the stealing part is just, they transform it into something that's wonderful,
That's the hope. That's the hope, is that your work is good enough that it's transformative. It's not, Picasso's not engaged. I mean, he uses the term theft because it's easy for us to understand. A $10 word for that William threw out earlier is called appropriation. Picasso and Braque,
actually, that word's $20.
$20 word. Are roommates, but even they are derivative, because a lot of the things that they're using as inspiration are things like West African masks. So the whole idea of these two, this Spaniard and this Frenchman, invented pictorial abstraction is a Western, racially biased, colonial type of point of view. They were collecting African masks with elongated faces and noses. If you look at, I'm going to mess up the French title, the Mademoiselles d'Avignon, the famous painting of the angular women that Picasso hid under his bed for 10 years because no one wanted it. those are all West African masks. That's where the face is derived from. So it's like if someone had copyrighted the idea of abstraction, I mean, where would we be? We're all engaged. Or figurative art. It's like, who owns the idea of figuration? You know, those belong to us collectively.
Yeah. William, you and I, just off before the meeting began, we had a conversation about the poor man's copyright. Can you give us some insight on what you would see as the poor man's copyright?
Well, I learned early on that when you were supposed to be like writing proposals and sending them off to the U.S. Copyright Office of declaring that you own the copyright to a particular image or a particular body of work, that you had to go through all these heavy processes. But, you know, unless you're going to be sued about your copyright, the real thing that you need to document is the date that you created it. And I know, Jim, now they don't even say you have to do that, but I think it's good to document when you created it. So if somebody creates a work after that point, that they can't claim that they came up with the idea or that image first. And the way you do it is you take a photo of what you're copywriting, and you put it in a letter, and you mail it back to yourself. So, and then you file it away, because now you have a U.S. government agency that has postmarked it with the date, and that is the date that you essentially got your copyright. So for 50 cents and the cost of an envelope, you know, basically that's the poor man's copyright.
Yeah, and William's correct. You don't have to do a lot of heavy lifting. I mean, we talked about keeping an inventory. This is another good reason to keep an inventory, is to keep track of when you made things, and that'll hold up in court. And I think we understand kind of collectively that justice is what's legal and what's just are not the same thing in this country. And so you may face an army of lawyers arguing against your perfectly valid copyright, and you may not win the day, but you can feel good because you're right. Maintain a sense of righteousness about it.
Yeah. I guess I'd like to, if I could, just talk about mixed media art and borrowing in the form of collage. Let's just say, you know, what are some of the cautions that you would, William, that you would maybe offer people if they were thinking about using collage in their work?
Well, I kind of bend to use collage in your work and use whatever you have. And, you know, I look back on artists that inspire me, and I think about how they appropriated like Andy Warhol appropriated the Brillo box and the soup can. You know, all of those things are cultural icons now. I say they're kind of cultural icons probably because Andy Warhol made them an icon. So, you know, did he copy them exactly? Not necessarily, but he also took photos and silkscreened them from newspapers. He ended up then kind of doing a lot of work where he used his own photos, his own Polaroids and things, and blew them up and made large screens. So when it comes to collage and cutting up magazines, yeah, there's a photographer behind those images that probably owns the copyright. There's probably a magazine corporation that owns the copyrights to the magazine and what's published in it. And so, but I think as creative artists, we gotta cut it up. Where the tricky part comes in is when you start making a lot of money off of what you created, and if something in that is a problem. But I think most of the time you're probably not using 100% of said image and then making money off it. So you're not taking the full photograph and publishing it and then reprinting it. And, you know, so that's when you get into where you have to have a really crafty lawyer to argue that, you know, you took, in terms of music, you know, you took three bars of music and developed it to your own new piece of work.
I'd like
Down below in the
Oh,
go ahead, Rebecca.
Oh, you go ahead, Jim.
Down below in the chat bar, while William was talking about Collage, I posted a link to Jeff Koons' reoccurring legal troubles over using collage-based elements. There are 3 instances in the article. I would encourage collage artists to read the last case, which I think is the one that Jeff Koons most successfully argued about the importance of collage in the justification. If you ever do find yourself facing any type of legal challenge about your use of collage, which is perfectly legitimate. Let me stress that. Collage is a perfectly legitimate way to make images. If you find yourself in court trying to explain to people who don't care why that's the case, this is a good case to cite. And if you want to look at that on your own time, it's worth the read.
I look forward to reading that. I appreciate you sharing that. I'm a mixed media artist, and I frequently incorporate collage into what I do, and I love it. I just love it. I love borrowing patterns and colors and shapes from other people's works, often from art magazines or photographs. But what I try to do in order to not be a dick is just to make sure that I don't even recognize it as part of the original. I try to cut it up or tear it and simply use a portion of it. Sometimes I'll even get my copy machine out and recreate that portion in different scales or through manipulations in order to create some variety. But I think it's a totally legitimate thing to do, especially if you make it unrecognizable. But then, you know, there are cases, like I was reading about this case by this guy, this artist named Prince, who basically took, I don't know if you can see this, but he took a photo of a Rastafarian and he put little blots over the eyes and gave the Rastafarian a guitar and called it his own work, and made a lot of money that the original photographer was not given any credit for, either as a thank you for, you know, for the inspiration, or no money, certainly. And this case, I mean, with even just those tiny modifications, this case went all the way through legal courts, higher courts, and those courts disagreed. Is this collage? You know,
I think we win the moral argument. Okay, even I'm going to say something that a lot of people here are going to find controversial. Even if that artist had simply taken the image as it existed, let's say they found it on Instagram, and they recontextualized it by putting it in a frame in a gallery, they have transformed it into a new work of art. That is the philosophical framework that's permissible. Now, would it have been nice to have received a print of that to the original artist? Would that have gone a long way to healing their hurt feelings? I think so. And again, that goes back to tip in the hat, is to nod to your source material. I think just to pull it out of our discipline and into the world of handbags. How many of you love handbags as much as I do, right? A good handbag is an artist's friend, and we know the names of some of those handbags. What are some fancy handbag designers these days?
Oh, Louis Vuitton, Chanel, you know.
Louis Vuitton, Chanel. Are the knockoffs cheaper?
Oh yeah.
Do you prefer the original or do you prefer the knockoff?
The knockoff.
Oh, why? Why do you like the knockoff?
Because it's accessible. I can afford it.
Interesting. That's very interesting that you find the let's say it's a Louis Vuitton, right? A very close facsimile of the original, maybe even constructed better, right? Maybe even utilitarianly more functional. What's interesting about this handbag argument is that generally they're not the same market. People who want the real thing buy the real thing. People who enjoy a bargain buy the knockoff. And those are not the same people. They do not shop in the same store. And so they're not really competing for the same market even. And interesting enough, neither of those things, neither handbag is protected by copyright. But you know what is? They're trademark. And that's why so much of the patterning on contemporary handbags are the trademark of the company. Chanel, Louis Vuitton develop their trademarks into a pattern that can be used as a fabric on the side of the handbag, and they can enforce their trademark protection on that. But if they just made a handbag, anyone can make that handbag, because what's not protected by copyright are things that are considered too utilitarian to be unique. So copyright does not extend to things like jokes, magic tricks, comedy, perfumes, recipes. I made a list. Clothing, furniture design, automotive design. None of those enjoy copyright protection. However, we all understand that automotive design has a certain appeal. And if you desire the Jaguar, you're not going to buy the knockoff of the Jaguar. You're going to save your nickels and dimes. You know, if this is the Kia knockoff of a Jaguar, it's not the same thing. And they don't satisfy the same market even. But neither of those things, no matter how unique they are, enjoys any copyright protection. And their market share, here's film, books, music, the food industry, the automotive industry, furniture design. A lot of industries that don't have any copyright protection at all have a much bigger share in terms of sales. And that's something to think about.
Well, let's talk about good manners then. So I think that as artists, I think it is nice and good manners to give credit where credit is due. I know one of the things that I do, and we talked about it a little bit before, is when I see a photo that's beautiful that a friend or an acquaintance on Facebook will put up, I will frequently ask, would you mind if I painted? And I've never had anybody say no. To me, that's just good manners. I've also taken and done videos or painted along with videos of other instructors and put, given credit to that person for, a great lesson from, or inspired by, or enjoyed studying with, that sort of thing. I think that can be nice manners too. It's not necessary always, but I think that can be nice manners. What do you guys have any other suggestions for how we could avoid crossing that line?
I think another good way of doing the right thing as an artist is recognizing other artists' copyright. So, if you're a painter and you have a photographer photograph your work, you should give them a shout out. So, when you post that image, you can say, the C and the symbol and copyright, your name, photography by whomever, so that you recognize that it's not your photograph. It was actually the photograph that someone else took for you. Now, you paid for it, so legally there's some kind of thing that you can use it. You have the license to use that the photograph. But it's always good to try and recognize that. And that comes to when, you know, you have people take your headshots for websites and use in the newspaper. It's always good to tell the newspaper who photographed you, because it's obviously, you know, unless you stood up a tripod or a selfie stick, that you didn't take it yourself.
I feel seen. It's always like this. I'm just. William is right, and Rebecca, I think both of those are really good strategies. One of the things that we can all do is to acknowledge where our source material comes from, because we're all working from source material. Even if you feel like you're working from a purely internal imaginative space, where do you think those ideas are coming from? They're fed by books and film and paintings that we have incorporated into ourselves and feel like ours after a while. When the legal thing that William touched on that I just wanted to mention is the work for hire clause within the copyright law. If you do work for hire, technically the person who hires you owns that. And so that's something to consider. I would imagine that would extend to commissions. So that might directly touch on a lot of people's lives. If you've been commissioned by someone to paint their portrait, you don't own the copyright. They own the copyright. And so
unless you tell them they don't own the copyright.
Unless you specifically state that clause. And even then, William, I'm like, I don't know. The courts may strike that down and say you can come to any understanding you want, but under the Constitution of the United States and our legal code, this is what's going to fly. And so they may, but I think, you know, again, the legality of something versus the morality of something is what we're discussing. And it's important to remember that many things that are perfectly legal are morally abhorrent. And so I would always encourage you to try to be a good person, to be the moral person and try to do the right thing.
Yeah,
And you usually can tell.
I think I might disagree just ever so slightly, based on the idea that it's my belief that as the artist, no matter who owns that painting, the only person who owns reproduction rights is me, unless I grant them to you. And I have, you know, even when I did a commission for Conway Hospital, I negotiated a separate licensing contract with them for the reprinting of the painting. It was over and above the, you know, just the painting fee that they paid me. And so I mean, here's a great example of just what you're talking about, how people can disagree, right? Because these issues are somewhat gray. William, where would you weigh in on something like that?
Well, I just go to, you know, what the law is, which I just posted for everybody. That is, you know, the title of the artwork, the ownership of that artwork goes to the person that commissioned the work, but the future use of that image and copyright still belongs to the artist. So if that artist wants to make prints and do it, they can continue to do it because it remains the copyright, unless it's signed over to them, to the agency, it remains with the artist. And so for the life of them plus 70 years.
There you go. I'm hoping that we're answering most of the questions that have come up for everyone in the chat box. If you've got any further questions, please feel free to write them in, or if we haven't answered them, please feel free to write them in again. Are there any other issues that you feel like we need to touch on having to do with ownership of imagery and just how we should be conducting ourselves, or concepts we should be thinking about as artists?
I think one of the more interesting recent developments in copyright law is alternative copyright attributions, and that is specifically the Creative Commons area of copyright. This is something that the kids have come up with, and so it's kind of new. And you often see it more on the internet with things like music, sometimes short films and images, but it is a layer of not having to go to the artist to seek permission. The artist at the time of creation is kind of telling you what you can do with their image. And so you may see things like attribution. You can use my image any way that you want. You just have to attribute it to me. Or it can be non-commercial usage. Anything that's not designed to generate a profit, you're welcome to use this image for. And those are little, if you visit Creative Commons, and I'll post a link to Creative Commons when I'm done talking, you can find different types of copyright signals that signal to people how you give them permission to use your work, your material, anything that you might want to. And a lot of musicians have turned to doing this because the music industry has been disrupted. But you know, it's like there was no copyright for music until we could record music and make it a tangible item. And now music is intangible, it's ones and zeros. So how do we buy and sell that again? And so the music industry is kind of, while we speak, going through a process of trying to figure out how to make money. And a lot of artists have figured out, it's like, I don't have to sell my music. My fans are more than happy to support me. And that's a model that a lot of us could make use of, to give your work away and to say, attribute to me, or please contribute. It's going back to a form of patronage that is equivalent to pass the hat. And because the internet gives us access to potentially billions of people, that hat can be really big. There are some artists who don't sell any music, who last year would make the equivalent of $1.2 million in donations from their fans, because
Wow.
people like artists.
Yeah, that's really neat to hear. I hadn't heard of, I didn't know about this Creative Commons thing. I'm really happy to know about it. I'll have to check it out. William, do you have any other just thoughts that you'd like to share that we didn't cover?
No, but I think it's when we talk about copyright, I think it's really interesting when you think about all these wine and paint places, you know, that everybody, a lot of them actually copyright the images that they have other people paint. So that, and the reason I know this is that I heard about a lawsuit that one wine and painting place sued another one because they took the same images that another group was doing and painted them for their patrons. And so the lawsuit was like, no, we painted those so that we could repaint them and license our guests who pay us to come to painting. So I thought that was a really interesting case.
How did it resolve? Do you know?
I think it was out of court, but the company that was suing the other company, basically they were told, go paint your own images.
So like a cease and desist went out.
Right.
Mm-hmm, mm-hmm. Well, that makes sense. I feel as if we're coming to an end of, and I think it's sort of a logical place for us to stop. What a great conversation, though. I think we've covered a lot of ground. Those of you who are out there, make sure that you check out some of the links in the chat. I think there's some really helpful information in the chat box there. So be sure to check that out. I want to thank Jim Arendt, and I want to thank William Miller again for joining me today. This was, I think, just a great, meaty conversation into what constitutes copyright and what are the issues surrounding that for us as artists, and there certainly are plenty. I'd like to invite you to think about coming next week to the next Friday freebie, which is going to be covering the topic of how to think about using social media or whether to use social media. There are certainly concerns that a lot of people have about what they lay themselves open to by being on the Facebook platforms and on the various other social media platforms in terms of privacy. That's going to be, I'm sure, a helpful conversation. There's so much to know. And if you're not really social media savvy, it might surprise you some of the things that can be done on the various social media platforms and how they interact with one another. Also, I want to invite you, if you're so inclined, to think about joining me for my next Wednesday Zoom class. We'll be working in watercolor and painting some dramatic daisies. And our Zoom classes have been so fun. They've been a really great way to interact as if we're all in class together and just paint together. I have the ability to sit and paint and demonstrate for the entire class, which is sometimes a difficult thing for me to achieve when we're all together in person. So it's been fun. And if you haven't been part of it, I hope you think about joining us. So I'll sign off for today. You can see this video in its full replay. You can share it with others or on your own social media. It's going to be up on YouTube probably later today. My channel on YouTube is Rebecca Z Artist, and you can find me there at RebeccaZArtist.com and also on social media and Instagram. So bye. Thank you, everyone. Have a great weekend, and I'll look forward to seeing you again soon, I hope.